Good morning. Today I want to say something about the important procedure involving the issue of a statutory demand to a company with a view to laying the foundation for a winding up order pursuant to section or part 5.4 of the Corporations Law. And those of us who practice in the area will know that the issue of a statutory demand under section 459 capital G of the Corporations Law will give the opportunity for a winding up to be established or started if there's not an application made to set aside the statutory demand within 21 days. And all sorts of questions arise looked at in great detail with respect to when the 21 days runs out and what needs to be done within that time period. And we know as a matter of High Court authority that it's not possible to extend the 21-day period. So we've got a procedure where the court is able to proceed on the basis that the company has a presumed event of insolvency if there's no application made to set aside the demand. And that leads to some interesting questions and difficult questions, because one basis upon which the demand may be set aside is if there is in fact a genuine dispute with respect to the demand. And a question that arises from time to time in practice is to what extent the underlying affidavits which establish the debt upon which the demand is said to arise can be examined and in fact can be attacked if for some formal reason there is some defect in them. That's the point we'll look at today. And that's been the subject of a very recent decision of the New South Wales Court of Appeal. Justices Barrett, Beasley, President, and Gleeson, J.A., in a case called Kisimul, K-I-S-I-M-U-L Holdings, Proprietary Limited, and Clear Position, Proprietary Limited, 2014, NSWCA 262. And it's on appeal from Justice James Stevenson, 2014, NSWSC 338. And in that earlier decision, His Honour Justice Stevenson examined the underlying authorities in very great detail to determine whether or not the omission of a particular statement in the supporting affidavit to the effect that the deponent had a belief that there was no doubt that the debt was due and owing was a vital part of it. In other words, if you're following the pro forma scheme, is there relief available if in fact the affidavit is formally insufficient or defective? And if we look at the rules here, section 459 capital E2 provides that unless the debt is a judgment debt, then an affidavit must do a number of things. First of all, it must verify the debt or debts as due and payable by the company, and it must comply with the rules. And in New South Wales, for present purposes, common rules all over the place of course, we've got the Supreme Court Corporations Rules 1999, Rule 5.2, and that provides that the affidavit which accompanies the demand must be in accordance with Form 7 and state the matters mentioned in that form and be made by the creditor or by a person with authority of the creditor or creditors and conform with various requirements. And Form 7 in its turn, when we look at it, stipulates that the affidavit in support must, among other things, state the deponent's status as a creditor or his other authority to make the affidavit, the source of his knowledge of belief, the debt or total debt which is payable, and finally, this is the key part in this particular case, that the deponent believes that there is no genuine dispute about the existence or amount of the debt or the debts. So, what happens if you leave part of that out? It's an informal, formal mistake I suppose, but that's a question. So, in Kisimul's case, the affidavit in support neglected to state the existence of the belief that there was no genuine dispute. Right, no genuine dispute. Now, if we look at it, it's pretty clear that an omission of that sort is not a defect in the demand itself. Right, section 459 capital J 1A attracts the possibility of relief from the court in setting aside the notice if there's some defect in the demand. Nor, as Justice Lunn pointed out in the Ceduna Marina Development, South Australian case 2012 SASC 23, should a properly sworn affidavit be described as defective. Rather, it's more appropriately described as inadequate. So, it's not a defect in the demand, but is it some other reason for setting aside the demand? And that, of course, attracts the jurisdiction under section 459 capital J1B, which is a broad sort of jurisdiction which provides that the demand can be set aside for any other reason. And if we look back to earlier cases, Justice Brian Tamlin, case in 2003, regarded the omission to set out the belief as a material failure of significance and not a mere defect within section 459 capital J2. And that confirmed the earlier decision or operative view of Justice Malcolm McClelland way back in B&M Quality Construction Proprietary Limited and Byride Steel, 1994, 15 ACSR 433 at 435, to the effect that the requirement of an express statement of belief is, as His Honour then said, a significant mechanism for filtering out cases where there is in fact such a dispute, so as to prevent such cases from reaching the court, with a consequent waste of time and resources. Alright, so we've got some pretty good authority looking back then, but if you leave out a formal part of that affidavit, you will have a particular problem. Now, as Justice Barrett points out, he gave the main judgment, Reg Barrett, at paragraph 18 in Kisimore, the jurisdiction conferred by paragraph in relation to any other reason is remedial. It's a provision which will be rarely employed, but when employed it will be for the purpose of meeting the demands of justice. Reliefs attracted by conduct described as unconscionable or an abusive process or which gives rise to substantial injustice. And in this area, as those of you who practice in it will know, we've got a large number of cases involving the Deputy Commissioner of Taxation, where it's been alleged that for various purposes of getting tax income back, a notice has been issued with a view to winding up the company. So it may be better in a sense to try to avoid attempts to categorise a reason for setting aside a demand in terms of interests of justice under section 459J1B in terms of unconscionability or abusive process, since doing so distracts from the real issue. Is there a good reason to deny effect to a statutory demand as creating a ground for the winding up of the debtor company? That is the key test. Is there a good reason for denying it? And earlier in Meehan Glazier Holdings, 2005 NSWCA 24, 53 ACSR 229, Chief Judge Young, Chief Judge in Equity, noted that it's not possible to set out fully the cases that might fall within section 4591B, nor if it were possible would it be wise to do so. The sort of case that will be covered will include gross defects in supporting affidavits and documentation, and where the alleged creditor has made statements or representations relating to a statutory demand which have reasonably induced a change of the alleged debtor's position. A judge, and this is a key point, is not at liberty to set aside it merely because he or she subjectively considers it fair to do so. Alright, well, what's the result? The important point in the paragraph in the affidavit, of course, is that it both informs the company served of the creditor's belief, but it also aims to instill in the creditor a sense of due attentiveness to the requirement that a debt other than an undisputed debt not be made the subject of a statutory demand. So, in Kisimore at 32 to 34, Justice Barrett summarised the relevant principles. First of all, the quality of the debt is central to the working of Part 5.4. So, it must be a debt which is due and payable, and it must be a debt, as His Honour said, which is uncontroversially owing, due and payable. Because if it's not, then no safe assumption will be made that the failure to pay is due to an inability to do so, which I guess picks up what Justice McClelland said a long time ago. It's a filtering mechanism. So unless you've got someone who's prepared to swear to the formal aspect of it, that it's due and payable, and you believe it's due and payable, then you can't base a safe assumption that the company is insolvent because it's unable to pay and therefore the subject of potential winding up proceedings. Secondly, the creditor has got to have a genuine belief that the debt is owing, payable and undisputed, and must conscientiously discharge the obligation imposed by section 459 capital E3. And the proper making of an adequate affidavit provides a significant measure of assurance that the objectives of Part 5.4 are being observed. So, in the absence of an affidavit swearing to the relevant information, that will remove the requisite level of assurance and puts the recipient company into a position of uncertainty and weakens the statutory measure contemplated by the Act. On that basis, in this particular case, an appeal was allowed from Justice Stevenson's initial decision not setting aside a demand. Well, to summarise, it's pretty clear that we've got to be absolutely punctilious about all the formal requirements with respect to Form 7 and the various other supporting statements which are required to go with the affidavit. It shouldn't be too hard to do so, of course. In this case, the absence was unexplained, but a failure to do so will, it would seem, in most cases, provide a reason under 459J1B, some other reason, to set aside the demand. And so that means you've got to be particularly careful in looking at any defect. And I suppose, as a counsel of caution, probably the party should simply, the solicitor should simply have been a bit more careful about what was being said. So the statutory demand procedure provides a very easy and simple method of proceeding with the view to winding up the company, or laying the foundation for doing so. But in effect, you've got to tick every box. You can't simply proceed on the basis that the court will in some way permit you, as a matter of discretion, to ignore mistakes which you've made in the formal documentation.